You wake up one morning and the highest court in the land has just unanimously decided something that will fundamentally alter how law enforcement can interact with you, your property, and your constitutional rights. Not a split decision, not the usual 5-4 or 6-3 we've grown accustomed to in our polarized era, 9-0. When was the last time you saw that kind of consensus on anything touching the Second or Fourth Amendment? This isn't just another legal footnote buried in the Federal Register. This is the Supreme Court drawing a line in the sand about how far the government can reach into your life without a warrant, without probable cause, without the basic protections our founders believed were non-negotiable. And here's what makes this ruling so critical. It doesn't just affect gun owners or privacy advocates in isolation. It affects every single American who believes that the Bill of Rights means something more than words on parchment. The implications are staggering, and most people haven't even heard about it yet. But you're about to understand exactly what changed, why it matters, and how it could protect you tomorrow. Let me be completely transparent with you right from the start. When I first read through the details of this Supreme Court decision, I had to stop and reread it 3 times because I couldn't believe what I was seeing. We live in an age where constitutional questions get twisted through political lenses so thoroughly that you can predict how a case will turn out just by counting which president appointed which justice. But this case shattered that entire framework. Every single justice, from the most progressive to the most conservative, looked at the same facts and reached the same conclusion. That alone should tell you something profound is happening here. The case itself originated from what seemed like a routine law enforcement interaction. A man in his own home, minding his own business, suddenly found local police at his door making demands about his legally owned firearms. No warrant, no probable cause, no exigent circumstances that would justify bypassing the Fourth Amendment's protections. Just a bureaucratic demand rooted in a state law that essentially said law enforcement could conduct warrantless inspections of gun owners whenever they felt like it. Now, if you're sitting there thinking this sounds like something out of a dystopian novel, you're not alone. But this wasn't fiction. This was real policy being enforced in a real American community, and it took years of legal battles to get it in front of the Supreme Court. What makes this case so fascinating is how it forces us to confront the intersection of 2 constitutional amendments that don't always get discussed together. We talk about the Second Amendment constantly. We argue about the Fourth Amendment when it comes to searches and seizures. But when you combine them, when you look at what happens when government power tries to intrude on both your right to keep and bear arms and your right to be secure in your person and property, you get into territory that makes a lot of people in positions of authority very uncomfortable. And that discomfort is exactly why this ruling matters so much. The legal arguments presented by the state in this case were remarkable in their audacity. Government lawyers stood before the Supreme Court and essentially argued that gun ownership itself creates a special category of reduced constitutional protection. Their position was that if you choose to exercise your Second Amendment rights, you automatically surrender a portion of your Fourth Amendment rights. Think about that logic for a moment. Imagine applying it to any other constitutional right. What if they argued that people who exercise their First Amendment right to free speech can be subject to warrantless searches of their homes to make sure they're not saying anything dangerous? What if practicing your religion meant government officials could enter your place of worship anytime without a warrant? The absurdity becomes obvious immediately, yet this was the argument being made with a straight face. The Supreme Court didn't just reject this argument. They dismantled it so thoroughly that reading the opinion feels less like a judicial decision and more like a constitutional law textbook explaining fundamental principles to people who should have known better. Justice after justice in both the majority opinion and the concurring opinions emphasize that constitutional rights don't exist in isolation, and they certainly don't cancel each other out. You don't lose one right because you exercise another. That's not how the Bill of Rights works. And the fact that this needed to be explicitly stated in a Supreme Court ruling tells you how far some jurisdictions had strayed from basic constitutional principles. But here's where it gets really interesting, and this is something that hasn't gotten nearly enough attention in the media coverage that has happened. The court didn't limit its reasoning to just firearms. The language in this decision is broad enough to apply to virtually any situation where government officials try to conduct warrantless searches based on the premise that you've exercised some other constitutional right. The precedent being set here extends far beyond the gun community. If you've ever worried about government overreach, if you've ever wondered whether your privacy rights mean anything in practice, this decision provides concrete legal protection that didn't exist before in quite this form. Let me walk you through what actually happened in the lower courts before this case reached the Supreme Court, because that journey illustrates just how broken our understanding of constitutional rights had become in some places. The initial district court actually sided with the government. A federal judge looked at this warrantless search scheme and said it was perfectly constitutional. The reasoning was convoluted, involving some creative interpretation of what constitutes a reasonable search and some selective reading of previous Supreme Court precedents. The gun owner appealed, and the case went to a circuit court of appeals, where a 3-judge panel also sided with the government. 2 out of 3 judges on that panel saw no problem with law enforcement entering someone's home without a warrant just because that person owned firearms. It wasn't until the case was reheard by the full circuit court, what's called an en banc hearing, that some judges started raising red flags about where this was heading. Even then, the circuit court split badly. Some judges wrote passionate dissents warning that approving this search scheme would eviscerate Fourth Amendment protections for millions of Americans. Other judges wrote equally passionate opinions defending the state's authority to regulate gun ownership through whatever means they deemed necessary. The circuit court ultimately ruled against the gun owner, which is what finally brought the case to the Supreme Court, and that's when everything changed. The oral arguments before the Supreme Court were illuminating in ways that transcripts don't fully capture. If you watch the video of those arguments, you can see the exact moment when the state's attorney realizes the case is slipping away. The justices weren't just skeptical of the government's position. They were openly incredulous. Question after question hammered at the same fundamental issue. How can you possibly justify warrantless searches of law-abiding citizens when there's no individualized suspicion of wrongdoing? The state's attorney tried every angle, every legal theory, every policy justification, and none of it landed. Because at the end of the day, the Constitution is pretty clear about what government needs before it can enter your home and search your property. Now, some people might wonder why this case took so long to reach the Supreme Court in the first place. Why didn't lower courts immediately recognize the constitutional problems here? The answer reveals something uncomfortable about our judicial system. There's been a decades-long trend in some circuits toward what you might call constitutional minimalism when it comes to gun rights, specifically. After the Supreme Court's decisions in Heller and McDonald established that the Second Amendment protects an individual right to keep and bear arms, some lower courts responded by upholding virtually every gun regulation that came before them, using reasoning that stretched those precedents beyond recognition. They developed a framework where they'd pay lip service to the Second Amendment being a real right, but then apply such deferential review to government regulations that almost nothing would actually be struck down. This created a bizarre situation where the Second Amendment existed on paper but had little practical force in certain jurisdictions. And when you combine that mindset with the general trend toward expanding government power in the name of public safety, you get courts that are willing to accept arguments they would never accept in other constitutional contexts. That's the environment that allowed this warrantless search scheme to survive as long as it did. It took the Supreme Court stepping in and saying enough is enough to restore some balance. The decision itself is worth reading in full if you have the time, and I genuinely mean that. Supreme Court opinions can be dense and filled with legal jargon, but this one is surprisingly readable because the justices seem determined to make their reasoning crystal clear. They start with first principles, explaining why the Fourth Amendment exists and what it was designed to prevent. They walk through the history of British soldiers conducting warrantless searches in colonial America, the exact abuses that prompted our founders to include these protections in the Bill of Rights. They remind us that these aren't abstract legal concepts. These are safeguards born from real experiences with government tyranny. Then they move to the Second Amendment, and here's where the opinion gets really powerful. The court explains that the right to keep and bear arms is, by definition, a right that exists in potential conflict with government power. That's the entire point. It's a right that exists specifically to check government authority, which means any attempt by government to condition that right on surrendering other constitutional protections is inherently suspect. You can't have a meaningful right to armed self-defense if exercising that right means government officials can enter your home whenever they want to inspect your firearms. That's not freedom. That's a permission slip subject to revocation. What really drives the point home is how the court addressed the government's policy arguments. The state tried to argue that these warrantless searches were necessary for public safety, that they helped ensure gun owners were storing their firearms properly and complying with various regulations. The Supreme Court's response was essentially, that's nice, but the Constitution doesn't have a public safety exception to the Fourth Amendment. If you want to search someone's home, get a warrant. If you have reason to believe someone is violating the law, establish probable cause and get a warrant. The existence of regulations doesn't give you carte blanche to ignore constitutional protections. This is where the decision becomes important, far beyond just gun rights. The court is establishing that you can't use regulatory schemes as an end run around constitutional protections. Governments have tried this in various contexts over the years. They create some licensing or permitting system, then argue that anyone who participates in that system has consented to warrantless inspections or searches. Sometimes courts have gone along with this in limited commercial contexts, but the Supreme Court is now saying very clearly that this logic doesn't apply when we're talking about fundamental constitutional rights being exercised in your own home. Think about the implications of that principle. We're living in an era of expanding regulatory states at both federal and state levels. More and more aspects of life are subject to licensing, permitting, registration, and oversight. If the government could use those regulatory systems as justification for warrantless searches, the Fourth Amendment would become effectively meaningless for anyone engaged in any regulated activity. This decision slams that door shut. It says that constitutional protections don't evaporate just because you're complying with some government registration or licensing scheme. The concurring opinions in this case are almost as interesting as the majority opinion. Several justices wrote separately to emphasize different aspects of the decision, and reading through them gives you a sense of the breadth of constitutional concerns at play. One concurrence focuses heavily on the property rights aspect, explaining how your home has always been afforded the highest level of Fourth Amendment protection and how that protection doesn't diminish based on what legal items you keep inside. Another concurrence digs into the historical understanding of the Second Amendment and how the founders would have reacted to the idea of government agents conducting inspections of citizens' arms. Spoiler alert, they would have been horrified. What you don't see in any of these opinions is the usual partisan split that characterizes so many Supreme Court decisions these days. There's no liberal bloc versus conservative bloc. There's no hair splitting over levels of scrutiny or parsing of precedents to reach different conclusions. There's just 9 justices looking at the Constitution and agreeing that what happened here was wrong. That unanimity sends a message that goes beyond this specific case. It tells lower courts that they need to take constitutional protections seriously, especially when multiple rights are implicated. It tells legislatures that there are limits to what they can do in the name of regulation. And it tells ordinary citizens that the Bill of Rights still means something. Now, I want to address something that's probably on some people's minds. Does this decision mean that government can never regulate firearms? Absolutely not. And the court is explicit about this. The decision doesn't invalidate reasonable regulations, licensing systems, or safety laws. What it invalidates is the idea that government can enforce those regulations through warrantless searches of people's homes. If police have probable cause to believe someone is violating firearms laws, they can get a warrant and conduct a search. If there are exigent circumstances like an immediate threat to public safety, existing exceptions to the warrant requirement would apply. What government can't do is create blanket policies allowing routine inspections of gun owners' homes without any individualized suspicion or judicial oversight. This distinction is crucial because it addresses one of the most common criticisms you see in response to gun rights decisions. Critics often claim that any decision protecting Second Amendment rights is putting public safety at risk. But that's a false choice. You can have both constitutional rights and effective law enforcement. You just have to do the work. You have to establish probable cause. You have to get warrants. You have to follow the procedures that the Constitution requires. Yes, that makes law enforcement's job harder. That's intentional. The entire point of constitutional rights is to make it harder for government to exercise power over citizens. We made it hard on purpose because we learned through bitter experience that unchecked government power leads to tyranny. The practical effects of this decision are already starting to ripple through the legal system. Multiple states had similar warrantless inspection schemes for gun owners, and those are now clearly unconstitutional under this ruling. Cases that were pending in lower courts have been sent back for reconsideration in light of this decision. Police departments are having to revise their policies and training materials. And gun owners who were previously subjected to these inspections are considering whether they have grounds to seek legal remedies for past constitutional violations. But beyond the immediate impact on gun laws, this decision is going to be cited in Fourth Amendment cases for decades to come. Defense attorneys will use it to challenge warrantless searches in contexts having nothing to do with firearms. Privacy advocates will point to it when arguing against government surveillance programs. Civil liberties organizations across the political spectrum will reference it as a landmark protection of individual rights against government overreach. That's the beauty of constitutional principles. When properly applied, they protect everyone regardless of the specific context. I think what strikes me most about this case, looking at it from a broader perspective, is what it says about where we are as a country right now. We're in this moment where trust in institutions is at historic lows, where people across the political spectrum feel like government has become too powerful and too disconnected from constitutional limits. And here comes the Supreme Court in a unanimous decision, reasserting those limits in clear and forceful terms. That matters. It matters for the rule of law. It matters for public faith in the judicial system, and it matters for the preservation of our constitutional republic. This isn't just about gun rights, though that's obviously a critical component. This is about whether we still believe that individual liberty deserves protection from government power. This is about whether the Bill of Rights is a living document that constrains what government can do, or just a historical curiosity that gets cited in speeches but ignored in practice. The Supreme Court just told us unanimously that these rights are real and they will be enforced. In our current political environment, that's actually remarkable.